glide into the next phase of our class today, which is still going to be on common law and equity. But if we are able to get someone reminding us of what we did, it will serve as a good foundation for us. So who is helping us? Yes, Muibat. Let's have.
Good afternoon, sir. In our last class, you started with common law. You said that common law was originated in England and it is based on the custom and tradition of the English people. And you said that it relies on judicial precedent, meaning like how would I explain this? You said that like when someone wants to take a case to the common law court, that the case must be related to an existing case in the courts that has been solved before. If not, the court will not accept the person's case. And you said that civil law is all the law is all the law except from criminal law, martial law, and military law. And you said civil law is based on the rights of individual. I think that's how stop.
Okay, thank you very much, Muibat, for that. Ifoma, let's have you.
Good afternoon, sir.
Yeah, good afternoon.
So you said we spoke on common law. You said common law are those rules that are based on the customs of the English people and the people of Wales. The common law is also another name for another names for the King's Court is called Curia Regis. I think Curia Regis. I don't know how to pronounce them. You said that common law is based on the rules of the doctrine of judicial precedents, that is the past court decisions. You said the King's Court is grouped into three. That's the King's Bench, the Court of Common Pleas, and the Court of Exchequers. You said that the Judicature Act was the Judicature Act was replaced, it replaced the King's Court, and at the time of 1873 to 1875, it said common law is very rigid. That means before you have to seek remedy, sometimes you will not even be able to seek remedy, and even if you are able to seek remedy, before your remedy will be accepted, it will take a long process. So that's why I say common law, sometimes justice is not served. Civil law, it says civil law is the core of all public and private laws except criminal law. Civil law excludes military, criminal, and emergency or martial law. It said it deals with disputes between citizens and allows them to express their rights and for their benefits, and it corrects injustice among we citizens. So it said the example of civil law are all laws are examples of civil law except the emergency or the military and the criminal law. That's all I have to say.
All right, thank you. That's another good version. Yes, Precious Oladimeji. Olamide. Let's have you.
Good morning, sir.
Morning.
So in our last class, we looked at the classification of common law and civil law, and we were given a bit of a history of how common law originated. And common law originated from England and Wales. That is based on the customs and norms of the English people of that time. And the common law has a bit of a similarity to the realist law school. That's in my own understanding, in the sense that it is based on judicial precedents. That is what the the decisions reached by the courts in previous court cases is what is upheld and followed. For example, judicial precedent simply means decisions that have been cases that have been given a particular verdict in the past, is applied in similar cases of the present. And a good example of how that is still being applied in modern societies is like in the Nigerian legal system, for example. The court cases and decisions made by the Supreme Court is seen as binding on the courts of lower levels. Okay, so a little bit more on the history of common courts. There were three main courts. There were three main common law courts, and they were the King's Courts, the Courts of Exchequer, and the Courts of Common Plea. The Courts of Common Plea focused on handling disputes between commoners, while the Court of the King's Courts, or the King's Bench, were cases that the king himself applied justice on. And when it came to financial roles or taxes or debts of the people, it was handled by the Courts of Exchequer. Then after the reforms of the Judicature Act of 1873 to 1875, if I'm correct, the three courts were merged together and they became one existing court. So the common law courts had a very rigid structure, and most of the people of that time felt that the common law was unfair. So whenever they had cases, they would usually, and they were not satisfied with the judgment passed by the common law court, they would go to the king for appeal. And over time, the king referred their cases to the chancellor, and a new court known as the Court of Chancery was created in the process. And that was what led to the development of the Court of Equity. But above all, common law court is based on judicial decisions, not statutes. And statutes are written and codified laws passed by a legal body. That kind of relates to what the entire civil law is about. And civil law covers every law, every public and private law, apart from criminal laws, martial laws, that is military laws, laws passed during a military regime where the constitution has to be suspended, and emergency laws passed during a state of emergency. Thank you very much, sir.
All right, Precious Olamide, thank you very much. Even though you said something I didn't say, which I noticed they are offshoots of your personal studies. And from the submission you have made, I can see that you have been reading and you've consulted some materials, which has put you ahead of, from the submission you made. That's okay. Keep it up. And at least from the feedbacks, it shows that many of us, if not all, are following us closely. All right, so thank you very much. Let me take it off from there. For those raising their hands, we may have opportunity next time. Thank you very much. So the second classification that we shall be looking at this morning is the common law and equity. We have already discussed equity and common law, and the excellent guys who gave us a summary a while ago did excellent jobs by creating a reminder of all that we did in our last class. So with your knowledge in common law, we now look at the other aspects of the topic, which is equity. Because of course, we are looking at it side by side. So now, if you have your understanding of common law, you will realize that because of the rigidity, just like Olamide was saying, because of the harshness, because of the various positions that the people considered as injustice, or because of the way the system of common law treated them, they felt that indeed common law system can be tagged as a very rigid system of law, which does not seek the general good of the community. That, oh, because of the practices and the forms in which they engage in, many people could not get remedy. And those that could not get remedy, or those who even got remedy, were not, put in the best way they were expecting. Of course, this is due to the fact that common law remedies were limited to some extent. It couldn't cater for many things which were expected, so to speak. And therefore, because of that, there was need for people within the society to seek for help, especially and directly to the king. So it is the harshness and the other characteristics of the common law that led to the formation of the class of law known as equity. So it should be noted as a foundation to whatever you are to discuss equity as a class of law, that it is the inadequacies of common law that led to the formation of equity as a class of law, especially as common law could not provide adequate justice to those who approached it for help. So what it led to was that plaintiffs or parties who could not get justice at the common law began to seek for other ways of getting justice. And in view of what we refer to as seeming injustice under common law, people started sending petitions to the king to use his prerogative to do justice. And the king, of course, was more amenable to giving or granting justice or doing justice. So he welcomed those petitions as a way of appeal, probably, of course, so to speak, from the common law system. As a matter of fact, many people who consider the rigidity attached to common law did not even bother to approach common law at all. And then the best they could do is to petition the king directly, asking the king to use the prerogative of his office to do justice to them. And consequently, equity was introduced to, one, ameliorate the form of a decree by, that came from the common law court. And then that led to the courts of chancery. The court of chancery is where equity, was practiced. So what happened was that when these petitions were being sent to the king could no longer handle these various requests because of how voluminous they were. And I can give you an example as it relates to our contemporary time. For example, you did a test. In this, probably you had a CAA test. And then everybody that wrote the test got 25/30. And about 10 out of the entire class got 20/30. And 1 out of the 10 felt, oh, this lecturer can be approached. Let me write a letter to the lecturer complaining and seeking to know why he or she got 20/30, especially when the majority of the class got 25/30. Even though the individual may forget that it wasn't the same energy that everybody in the class deployed to be able, to write the exams. Because it's very possible that while some were reading and studying, some were attending to other businesses. Because these days, students are even more businessmen and women than those who profess to be. So maybe some of you or the individual had focused more on his business than studying for the test. Whereas there were people in the class or members of the class that burnt the midnight oil. Even during the day, they sacrificed practically everything to prepare for the test. But because the individual felt, if I can write a letter to the lecturer may consider me. And then the student wrote. And when I looked at the letter, I felt that, okay, let me do a remark of what this student has done. And I discovered that I made a mistake in the assessment. And then I did a correction and sent the new mark through the class rep to the student. And one way or the other, the class rep decided to post the outcome of the letter on the group chat. And then those who were in this category saw that, when this man wrote, when Deborah wrote, she got a response. And that response was favorable. I can assure you that the remaining 9 people will do the same thing. That can be likened to what happened when equity was being formed. So many people began to write petitions to the king, and the king became overwhelmed by virtue of the numerous petitions that were sent to him. And what the king did in his wisdom was to appoint chancellors, people who were already in his government, who were referred to as cleric, but technically referred to as chancellor. And the petitions were forwarded to the chancellors. The king delegated his powers to them so that they could attend to dissatisfied litigants. And all of these happened around 14th century. So over time, the Court of Chancery, made up of the Chancellor, developed a body of principle known as equity. And that's why, for those of you who are familiar with some sayings in law, even though you may not know that it originated from what we are talking about here, you will hear that he who comes to equity must come with clean hands. Meaning that if you must come to equity to seek for help, your hand must not be dirty. For example, if an harlot, a prostitute, comes to the king to say, this man engaged my services, and after all we did, he refused to pay me. And meanwhile, the act of prostitution has been proscribed in the society by the king or by the people or authorities having powers to do so, that no one is permitted to practice prostitution in this community. This prostitute has forgotten, and he went to the king and said, my lord, may the king live forever. This man engaged my services, and after performing and discharging the responsibility on my part, he refused to pay me. The thing is that the hand of this prostitute is already dirty, because the act that they did is illegal. So therefore, the king will first of all probably arrest her for going contrary to the rule of the society, that no individual, no one should participate in prostitution. So, meaning that her hand is not clean. Therefore, she cannot get remedy from the king. So, that is a simple way to explain that principle of equity, that he who comes to equity must come with clean hands. If you are seeking for something, it must be something deserving. And that's why in law, the law is not allowed to be used to perpetrate injustice or criminality. That's why in the Latin maxim, "es dolo mano non oricho acho," means that the law cannot be used to enforce illegality. In that example I gave to you, prostitution is an illegality. Therefore, the king cannot cause the man to pay. Asking the man to pay is like enforcing illegality. So you can also search for other principles of equity to aid your understanding. But as it relates to this class, those principles that were developed by equity, were developed in the Court of Chancery, is what is known as equity. And this supplemented common law by providing more flexible remedies. What are these remedies that the Court of Chancery provided? This included injunctions, specific performance, and so on and so forth. Maybe at the court of at common law, all that a litigant could get is damages, and that these damages were not sufficient in ensuring justice. Now, if somebody has entered your plot of land and the individual is building on it, and then you saw him and ran to court, and all the court could do for you is asking the man to pay you damages, and the man paid you damages and still continue to build on that land, you will not have achieved anything by that remedy that the court provided. But what if the court had given an order asking that man that is building on your property to stop forthwith and come to court to explain why he or she is building on your property? That will have saved you some more stress than the court just giving you damages. So what the Court of Equity did was to introduce things like that, and that is what is technically known in law as injunctions. Of course, there are different types of injunction, but those are not to be discussed in this class. So what we are saying in essence is that the coming into place of equity brought some more flexible remedies to the community. But again, like I said, these were administered by the chancellor, who were regarded as the keeper of the king's conscience. So the chancellors granted redress on behalf of the king or the royal council on the basis of what his conscience deemed right in the circumstance. So what you get from the chancellor is the product of his thinking. What do I mean? Different people see different cases differently. So if you go to the judge, to the chancellor, and what this particular chancellor is seeing is different from what the other person gets or is seeing, you can only get the judgment that that particular chancellor is giving to you. And this is one of the major features of the Court of Chancery, that the decisions were based on the conscience of the particular chancellor who was, listening to the petition that was sent to the king. So this system gradually became institutionalized into the Court of Chancery, and the principles formalized, like I said earlier, is what is known as equity even till today. So we have established that due to the hardship generated by the common law, the principles of equity, or the court or the class of equity, of law known as equity, came into existence. Now, we had some conflict between equity and common law. Mind you, if the common law court had given a judgment, and then the people that got the judgment, or that the judgment was not in his favor, decide to run to the Court of Chancery how do you think the court of chancery or the court of common law will feel? So what happened was that by reason of the developments taking place in the chancery, court of chancery, there were a lot of conflict or tension between common law and equity courts. And this led to different conflicts, especially in cases where their decisions were different from each other. This continued until when the case known as Earl of Oxford case, Earl is spelled E-A-R-L, Earl of Oxford case, which happened in 1615. And in that case, King James I gave a judgment that equity will prevail in cases of conflict between the judgment obtained at common law and equity. So that is one major thing that you need to note about this particular class of law, that there was conflict between common law and equity, but at the end of the day, whichever judgment is given, the judgment emanating from equity is deemed to be the final judgment in that particular case. Now, let's come down home to ask that what is equity? Because we try to define common law in the course of our deliberations. So therefore, what does equity means? Equity means fairness. It means something just or natural justice, or something that can be tagged to as morally right and good. So that is what we mean simply by equity. And this, of course, like we said, is difficult to understand, because what is fairness to this person may not be what the other person consider to be fair. But of course, what is fair was the focus. But how you arrive at what is fair is a major issue. But that is the explanation that can be provided in that. So this development led to equity enforcing rights that were not recognized at common law. Okay? Like I said before, injunction, specific performance simply means if you have agreed to carry out an obligation, you have been paid for it. For example, you must find a way at all costs to discharge that duty. That is a form of remedy that the Court of Equity brought to play. So, what we are saying further is that the Court of Equity helped to enforce the rights that were not recognized at common law, to make life simple or simpler for litigants who were going before the court. Mind you, common law and equity at that same time continue to exist. And of course, that was why what led to the tension that I explained earlier on. And by the Judicature Act of 1873 and 1875, both the common law courts and the courts of chancery were merged into a single court. Okay? The common law courts and the court of chancery were merged into a single court. And both these courts, even though comprising of two unique systems, were tasked to administer both the common law rules and the doctrines or principles of equity. And it was understood that where they began to apply both principles, and when there is conflict, equity will always prevail. I mentioned that earlier. And of course, what brought about that situation was the Judicature Act of 1873 and 1875 that made the common law court and equity into a single judicial system. And of course, the both of the rules of equity or principles of equity and that of the rules of common law were applied side by side. But where both had conflict, the rules of equity prevailed. And that is all, or the summary of what we can say about equity and common law. I think there are some hands being raised here, which I believe are for questions. Like the question and answer tab is also open. You can send in your question. Let's take Mausi.
Good afternoon, sir.
Good afternoon.
Sir, after you said the Earl of London's case and then you went ahead to say the king, I really did not get that part.
You didn't get
The Earl of London's case,
of
the explanation after about the king.
Yes. And the Earl is spelled E-A-R-L. That's Earl of Oxford case of 1615. So what I said there was that the issue relating to the differences or the conflicts between common law and equity was resolved, and that it was in this case that King James I ruled that where there is conflict between the common law rules and doctrines of equity, that of equity will prevail. Do you understand now?
Yes, thank you, sir.
Adedoyin Eunice. How do you, okay, she has gone. Adedoyin, yes. Your network is not good. You can send your message to the question and answer part. Agbojule.
Sir, good afternoon, sir.
Good afternoon.
When you said that if a court of that court of common plea, if it doesn't favor the person that went to the place, then it will go to the King's Court. So are you saying the King's Court is higher than the common plea in that situation?
The king was a separate authority on his own. You know, it was the king that created the court. But despite the fact that the king has vested some powers in the court, the king still had his own power. So it could serve as a form of appeal for cases coming from those courts that were established. Okay?
Okay, sir.
Yes. Next person. Tokes Omega. Okay, let me respond. Oni Rachel.
Good afternoon, sir.
Good afternoon.
Sir, the question I wanted to ask, you said that the court of equity was led by the chancellors. But then when I was studying in a place, I saw bishops there. So I just wanted to clarify that was it both chancellors and bishops, or it was kind of like a church thing?
No, what I said earlier, that these chancellors were clerics. He is a bishop, a clergyman.
Yeah.
Yeah, so I think your answer has come.
Yeah,
Okay?
sir.
So Ifeoma
Good
is
afternoon.
asking, why was common law court not dissolved if equity will always prevail? Well, maybe in the wisdom of the king then felt that there were some areas that common law court will do justice and probably better than court of equity. But the king, with wisdom, chose to keep the two.
Ebaniel.
Someone said in a question, there's somebody here disturbing us. What kind of human being is this? Agbojule, please mute your mic. So going back to the question and answer section, someone said, I don't know, prostitution was a crime. Why should she be denied justice? Well, if you don't know that prostitution, and mind you, that's example I gave you was an analogy because you weren't listening properly. But if constitution is not a crime, you probably be seeing series of adverts, or you have shops. You see people register to say we are association of prostitutes, and then but what I was saying there was an analogy. But if you think it is not a crime in Nigeria, you can make an attempt to register a company known as Association of Prostitutes of Nigeria and see what will happen. Another question is there an incident that led to the Judicature Act of 1873 that made both common law court and equity courts? Where as the society grows, a lot of things happen and there is need to make different laws. So I cannot say specifically what happened, but I believe that it was the happenings in the society that led to that development. Another person is asking, sir, what name was given to the court when they were merged? Well, they were just merged into a single court, and both of them were to act as a single court, applying both the system of equity and also common law. Now, someone said, sir, I did not get that Judicial Act of 1873. I did not get that place, sir. Can you please come again? Where am I coming to? I said Judicature Act. Judicature, not Judicial Act. So, Judicature is spelled as J-U. I hope you are listening now. Judicature. T-U-R-E. J-U-D-I-C-A-T-U-R-E. Okay, Judicature Act. All right, so I think I've taken practically all the questions in the Q&A. Someone says, sir, the law of equity applied in Nigeria? Yes, our court apply principles of equity. Okay. All right. So that's okay. Please, can I have just 1 minute? Okay, so that is the lecture on equity and common law. The next class we move to is public and private law. Public and private law. Now, when we talk about public law, it is concerned with the protection of the state and its organs. Also, preservation of the good order of the society. That is what we mean by public law. It is concerned with just a minute, let me quickly attend. Hello, class. So, laws that deals with the protection of the state and the various organs of state is what is referred to as public law. They also talk about deals with how the society can be properly organized without any form of havoc. And that's why when you commit a crime, it is the state. If you commit a crime against your neighbor, it is the state that takes over the prosecution as if you have done something wrong to government. So that is what public law primarily concerns itself with. Now, public law regulates the relationship between the state and the citizens. Now, I usually say that you know that government, as powerful as they are, they still have a duty to listen to what the citizens have to say. And that's why when there is demand from the society, maybe people come out to protest and said what the government has said, we don't want it, we no go agree, we no go agree. The government is forced to listen to what the people are saying. Why? Because there are provisions of the law that makes the interests of the society to be paramount than what the leaders feel or what they think they want. So, and that's why when you have a property, for example, and that property is duly registered, the government cannot wake up to take it off from you without a valid reason, such as, okay, we want to use it for a school, which everybody in the society will benefit from, or we want to use it for markets, or we want to use it for this and that. So they cannot just wake up and take it over, because the law makes provision for how they must relate with the citizens. So public law deals with the rights and duties of individuals to the state and vice versa, like the administration of government, public revenue, and public security. And that's why we say that the primary essence of government is security. That where a government is not able to provide security, then that government is not fit to be in place. And also what the government must do for the citizens and what citizens must also do for the nation or to government. For example, payment of taxes and other things like that. All of these are regulated by public law. So, examples of public law therefore includes constitutional law. And that's why the government cannot do anything outside the powers given to them. Another example of public law is administrative law. Another one is criminal law. And another one is international law. Now, what do we mean when we talk about criminal law? Like I said earlier, why is it that when an individual look at the recent case of the acclaimed gospel musician killed his girlfriend, you discover that it is the state, the government, that is dealing with the case, that is making an attempt to sue the individual and to get justice for the family, and not the family doing the case or prosecuting the case, except that they can be called upon to come and give evidence in order for the court to be able to do justice in the case. So you notice that the criminal law of Nigeria deals with issues that pertains to crime and how the society can be preserved and in the benefit of everyone living in the society. On the other hand, private law means the law that governs the relationship between individuals. That is the law that regulates the rights and duties between private individuals to one another. For example, you want to buy a lace from a cloth dealer. And the cloth dealer said, this cloth, 12 yards, cost 12,000 naira. And the person did transfer of 12,000. And suddenly, the cloth seller was willing to.
In the book of Mark chapter 9, a man brought his son that was a lunatic. He was going to call it Apostle. What dangerous sickness. If you see someone that has this sickness, you can even choose the person. Because you can never know that the person has Apostle. The person can wear.
Some of you are not serious at all. It's okay. Continue. That's all I can say. So, if after you have paid money, the individual, please give me 1 minute. So, if you happen to take the case to court, the law that will govern that proceeding will be private law, because it is seeking to address the rights of parties that participated in the contract. Again, private law deals with the protection of individuals' rights. Example of private law includes law of contracts, law of tort. Tort is spelled S-T-O-R-T-S. Torts. Another example is family law. Another example is commercial law. Another example is banking law. All of these deals with private rights. So, while public law deals with issues pertaining to public order, preservation of the state and its organ, private law simply deals with the rights of individuals within the society. So we move on to the next one, which is civil and criminal law. Mind you, we have discussed common law and civil law. We have looked at common law and equity. We have also looked at private and public law. Now we want to look at civil and criminal law. Okay? We begin by looking at the definition of civil liability. Or let's refer to the case of Nuna versus Director of Public Prosecution. I will spell the NUNA as KNULLER. NUNA versus Director of Public Prosecution, where Lord Diplo stated, and I quote, he said, civil liability is concerned with the relationship of one citizen to the other, while criminal liability is concerned with the relationship of citizen to society as a state. That was what the court held. In the case of NUNA, that is KNULLER versus Director of Public Prosecution, where Lord Diplo stated that civil liability is concerned with the relationship of one citizen to another, while criminal liability is concerned with the relationship of citizens to society as a state. So civil law is a law that defines the rights and duties of persons one to another. And again, civil law provides system of remedy. Just like what we saw under equity. Just like what we saw under common law. That common law provided some remedies, but equity brought about more flexible remedy for litigants. So civil law is the law that defines the rights and duties of persons one to another, and it provides a system of remedy. It entails a system where an individual who is injured by the wrongful act of another can be compensated for the damage which he has suffered. Maybe, for example, a breach of contract. The court can say, Madam, you have collected money. Therefore, you must deliver the goods that you have been paid to deliver. So, that is what civil law is all about. Example of this includes law of contracts, law of torts, like I said earlier, land law, and family law. So civil wrongs lead to recovery of money or enforcement of rights, but not punishment. Criminal law defines the acts or omission which are against or contrary to public order and the society as a whole, and which render the guilty person liable to punishment. Criminal law defines what a crime is. It provides for what the person must do to say that he or she has committed a crime. And then usually, criminal law provides punishment for whatever wrong an individual has done. So crime may be serious, such as murder, rape, among others. It can also be lesser offenses, such as minor traffic offenses. But all of them falls within the class of criminal law. So what it means, therefore, is that whether just a minute. Okay, sorry for that break. I needed to enable another class. All right, so crime may be serious or may not be serious. We're giving examples. And to succeed in a criminal trial, the prosecution has to prove his case beyond reasonable doubt. I'm sure practically everybody in this class must have heard that before. But in a civil wrong, the plaintiff need only to prove his case upon the balance of probability. What does that mean? You must have seen a scale. You must have seen the symbol of justice where a scale is held. That balance of probability, if the scale is even, is doing 50-50, that means nobody is winning. But when there is 51% over 49, the scale has tilted to one side. So if you continue to put evidence in the box and it now makes the scale to tilt towards the other side, that is to say that the probability is high on the other side, and then the person who has more is the one who carries the day. So in criminal case, like I said, it must be beyond every reasonable doubt. But note that there may be some overlapping in both systems of law, meaning that there are some acts that can be a civil wrong and also be a crime. Possible that you may be hearing that for the first time. There are some acts that can be a crime at the same time a civil wrong. Example, we have assault, where someone inflicts pain or touches you without your consent or cause some bodily harm to you without your consent. That is an assault. It can be a civil wrong. It can also be a crime. Another overlapping in this both system is that it's false imprisonment. It can both be civil and criminal. Okay? Whichever way it is, the plaintiff has plenty of demand on his side to prove the case beyond reasonable doubt in a criminal court and on the preponderance of evidence when we're talking about civil wrong. So basically, these two systems of courts exist side by side. Why civil law deals with rights and obligations of citizens, criminal law deals with criminal liability and how the state handle such cases. So that is the short summary or short lecture on this topic of criminal and civil law. Do we have any question? Because we are going to stop here for today. And by God's grace, when we reconvene, we will start from substantive and procedural. Any question? Well understood? All right. In the absence of no other question, we can call it a day here. And then by the time we meet again, we take it off from there. Thank you very much for listening and enjoy the rest of your day.
Thank you, sir.
Yes.
Have a good day, sir.
You too.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Very much, sir.
Thank you, sir.
Yes,
Sir.
Thank you, sir.
Sorry, I'm using attendance, please.
Sort of the attendance.
He said he will use our usernames to judge who attended and everything.
I'll get my attendance from the Zoom participation, so don't worry yourself.